Hello everyone, my name is FENGSHEN and I'm doing introduction part. So for introduction, children are among the most vulnerable members of society and are therefore afforded special protection under the law, as they depend on parents or guardians for their care, safety, and development. The law recognizes that intervention may be necessary where parental care is inadequate or has broken down. This reflects the fundamental principle that the best interest of the child should be the paramount consideration in all decisions affecting children. In Malaysia, the Child Act 2001 provides the primary legal framework for the care and protection of children. Section 17 plays a central role by identifying the circumstances in which a child is considered to be in need of care and protection. The provision recognizes that risk to a child's welfare may arise in different ways, including abuse, neglect, and failures in parental care or supervision. By allowing the relevant authorities to intervene before serious harm occurs, Section 17 seeks to safeguard the child's welfare and promotes his or her healthy development. This essay considers how Section 17 protects the best interest of the child by examining 4 situations under the Act, where a child has been abused or is at substantial risk of abuse under Section 17 sub 1 sub A, where a parent or guardian fails to protect a child from known harm under Section 17 sub 1 sub B, where a parent or guardian is unfit, neglectful, or unable to exercise proper supervision and control under Section 17 sub 1 sub C, and where a parent or guardian neglects or is unwilling to provide adequate care, food, clothing, and shelter under Section 17 sub 1 sub D.
Good day. My name is RITISHA and my part of the presentation focuses on Section 17 sub 1 sub A of the Child's Act 2001, which concerns children who have been abused or are at substantial risk of abuse. Section 17 sub 1 sub A provides that a child is in need of care and protection where the child has been or there is a substantial risk that the child will be physically injured, emotionally injured, or sexually abused by his or her parent, guardian, or a member of the extended family. This provision is significant because it recognizes that children are among the most vulnerable members of society and are often unable to protect themselves from abuse. Instead of waiting until serious harm has already occurred, the law allows intervention once there is a substantial risk of abuse. This preventative approach demonstrates that the Child Act 2001 prioritizes the best interests of the child by allowing welfare authorities and the courts to act before irreversible harm occurs. The scope of protection under Section 17 sub 1 sub A is further explained in Section 17 sub 2 of the Child Act 2001. First, a child is considered physically injured when there is a substantial and observable injury caused by the non-accidental use of force. For example, includes fractures, burns, bruises, lacerations, hemorrhaging, or the loss of consciousness. Second, a child is considered emotionally injured when there is substantial impairment of the child's mental or emotional functioning. This may be evidenced by anxiety, depression, aggression, withdrawal, behavioral disorders, or even delayed development. This definition is important because abuse is not always physical. Emotional abuse may leave no visible injuries, yet its effect on a child's development can be equally severe and long-lasting. Third, a child is sexually abused when the child participates, whether directly or as an observer, in activities of a sexual nature for pornographic purposes or sexual exploitation. The Act therefore recognizes that children require protection from all forms of sexual exploitation, regardless of whether physical violence is involved. By providing these definitions, Section 17 ensures that child protection extends beyond visible injuries and adopts a comprehensive approach that protects the child's physical, emotional, and psychological well-being. The importance of protecting children from abuse has also been recognized by the Malaysian courts. For example, in the case of PP and Muhammad Ridwan Abdul Razak 2015, the federal court emphasized that children are particularly vulnerable victims of sexual offences and require special legal protection. The court acknowledged that offences involving children cause profound and lasting harm, thereby justifying stronger legal safeguards. Although the case concerned criminal liability for sexual offences, its underlying principle supports Section 17 sub 1 sub A, namely that the law must prioritize children's safety and welfare because they are incapable of adequately protecting themselves. Academic research further reinforces the importance of the provision. Gilbert and his co-authors writing in The Lancet found that child maltreatment is associated with long-term consequences such as depression, anxiety, substance abuse, behavioral problems, and poor physical health, extending into adulthood. Their findings demonstrate that abuse during childhood affects not only the child's immediate safety but also future emotional development, education, and social relationships. This supports the preventative approach adopted under Section 17 sub 1 sub A, which seeks to intervene before abuse causes irreversible damage. Similarly, Marni Arumugam argues that the best interest of the child should be the primary consideration in all decisions affecting children. She notes that although Malaysia has incorporated many child protection measures through the Child's Act 2001, there remains a need for clearer legislative guidance to ensure that the best interest principle is consistently applied. This supports Section 17 sub 1 sub A as allowing intervention where there is a substantial risk of abuse, places the child's welfare above parental autonomy, and enables authorities to act before irreversible harm occurs. Ultimately, Section 17 sub 1 sub A gives practical effect to the principle of the best interest of the child. By recognizing physical, emotional, and sexual abuse, as well as the risk of future abuse, the provision enables early intervention to protect children's safety, dignity, and healthy development. Rather than reacting only after a child has suffered serious harm, the law adopts a preventative approach that places the child's welfare at the center of decision-making. Through comprehensive statutory definitions, judicial recognition of children's vulnerability, and support from academic research, Section 17 sub 1 sub A serves as one of the most important mechanisms for ensuring that every child has the opportunity to grow up in a safe, secure, and nurturing environment. That's all from me. Thank you.
Good morning, my name is Stephanie Fu. I will talk about one of the situations in which a child is considered to be in need of care and protection under Section 17 sub 1 sub B of the Child Act 2001. Section 17(1) sub 1 sub B applies when a child has been physically injured, emotionally injured, sexually abused, or is at substantial risk of such harm, and the parents or guardians knows about the injury, abuse, or risk but has failed to protect the child or is unlikely to protect the child. However, the term substantial risk used in Section 17(1) sub A and Section 17(1) sub B is not clearly defined in the Child Act 2001. Therefore, English cases may be used as persuasive authorities. In Northamptonshire County Council (NS), the court explained that significant harm must be assessed by comparing the child's condition with that of a normal child in similar circumstances. Section 17(1) sub A focused on abuse caused by the parents, guardians, or family members. Section sub 1 sub B is different because it focuses on the parents or guardian's failure to protect the child, even if the harm comes from another person. For example, Section 17 sub 1 sub B may apply if a mother is aware that her husband is abusing her child but chooses to leave the child with him without reporting or stopping the abuse. In PP and CD by Nun Ahad Razali, the accused was charged under Section 31 sub 1 sub A of the Child Act 2001 for abusing and neglecting a 13-year-old girl with Down syndrome. The child suffered physical and emotional injury while under the accused's custody. This supports Section 71 sub B because it concerns with protecting a child from injuries, abuse, or serious risks, especially when the parents or guardians knows about the risk but fails to protect the child. In PP and Asmarani binti Ghazal, the court explained that child abuse includes any acts or omission by a parents, guardians, or caregiver that endangers or impairs a child's physical or emotional well-being. Therefore, Malaysian courts treat failure of care seriously when a child is exposed to harm. According to the journal article on parental liability law in Malaysia for children's misconducts, it explains that parents may be legally responsible when they fail to supervise or protect a child after knowing there is a risk. This is relevant to Section 17(1) sub B, where the parent or guardian knows that the child has been abused, injured, or is a risk but still doing nothing. Therefore, parents and guardians are not passive figures. They must take action when they know the child is at risk. Section 28 of the Child Act 2001 states that family members are required to report suspect physical and emotional harm caused by mistreatment, neglect, abandonment, or exposure. Malaysian cases such as Malcolm Fernandez and Melissa Mary Albert and M&M case shows that where there are reasonable grounds to believe a child has been harmed or sexually abused, family members have a duty to report it. Therefore, a parent or guardian who knows about the abuse or risk but still remains silent is clearly falling in their protective role. According to Aru Mugam and Karim, the Child Act 2001 does not contain a general best interest provision, but the principle appears in specific circumstances, especially where the courts for children's protectors or Director General is involved. When a child is brought before the Court of Children, the child's best interest must be the paramount consideration, especially where the child needs care, protection, or rehabilitation. In conclusion, Section 17(1) sub B protects the best interests of the child by focusing on failure to protect. It prevents parents and guardians from avoiding responsibility simply because they are not the direct abuser. If they know about the harm or risk and do nothing, the law will step in to protect the child. Thank you. That's all from me.
Hi, I'm Wei Xin, and today I'll discuss Section 17C of Malaysia's Child Act 2001. This is one of the grounds of which a child is found in need of care and protection, and I'm going to discuss how it operates within the best interest of the child principle and drawing on the Act's Protect Statutory Scheme, Malaysian case law, and also academic commentary. Under Section 17(1)(c), a child is in need of care and protection where the parent or guardian is unfit, has neglected, or is unable to exercise proper supervision and control over the child, and the child is falling into bad association. Once this threshold is met, the Act's protective machinery is triggered. A protector or police officer may take a child into temporary custody under Section 18, and the child must be produced before the Court of Children within 24 hours under Section 19, and the court may then give a protective order under Section 30. So the best interest standard underlying Section 17C has deep roots in Malaysian family jurisprudence, which the Court for Children draws upon when interpreting the Act's protective provisions. In Mahabil Prasad and Mahabil Prasad, Justice Ajab Singh held that the welfare of the child is the first and most paramount consideration. This was affirmed by the Federal Court, which was then under Chief Justice Raja Ahsan Shah, and in Tae Eun Kim and Yu Peng Siong, where it was held that parental rights are overridden if they are in conflict with the welfare of the child. This is precisely the logic of Section 71C, where the parent is unfit, neglectful, or unable to supervise, parental authority yields to the state protective jurisdiction. In Sino Casey Patterson and Chan Hong Po, the federal court, through Federal Court Chief Justice James Fong, held that the welfare of the child encompasses the child's well-being in the most widest sense. This includes religious, moral, physical development, happiness, and of course, their security. As Sidhu notes in his overview of the Child Act, such welfare-based common law principles inform the court for children's protective jurisdiction, even though Part 5 proceedings are confidential under Section 15 and rarely produce openly reported judgment. This makes this analogous custody jurisprudence the clearest judicial articulation of the welfare standard applied. To make this concrete, consider three scenarios that typically fall between Section 71C. First, a child suffering from chronic drug addiction who is typically absent or incapacitated, leaving a 13-year-old child unsupervised for days at a time. The child begins skipping school and associating with an older group involved in petty theft. Here, the parent is plainly unable to exercise supervision, and the child is falling into bad association. Second, a single working parent holding two jobs who, despite good intentions, leaves a 14-year-old alone from early morning to late night with no alternative supervision arrangement. The child gradually drifts towards a peer group involved with vandalism and truancy. This illustrates neglect arising from circumstance rather than malice, and the act's focus on the supervisory gap itself is not the parental blame. Third, a guardian who is mentally unwell or has effectively abandoned the household, such as an orphan child in their care begins staying overnight with gang-affiliated youths. This reflects outright parental unfitness, as Mama Desa observes in her study of children under Malaysian criminal law. Such cases show why the Act's Child in Need of Care framework, rooted in the UNCRC principles of non-discrimination and best interest, treats the child in such a scenario as a victim of a field support system and not an offender. So, to sum this all up, Section 71C, read together with the welfare jurisprudence in Mahabir Prasad, Kim, and Sino Casey Patterson, translate the best interest principle into a concrete, proportionate legal machinery that identifies parental failure as the trigger for protection rather than punishing the child. Thank you.
Hello, my name is Zheng WENBO, and my part focuses on children who were exposed to moral or physical danger because their parents failed to provide proper care. The relevant provision is Section 70 sub 1 sub D of the Child Act 2001, which provides that a child is in need of care and protection, whether the parent or guardian neglected or is unable to provide adequate care, food, clothing, and shelter for the child. Unlike physical or sexual abuse, the provision recognizes that parental neglect alone may seriously endanger a child's welfare. Therefore, the law allows intervention before the child suffers irreparable harm. Section 70 sub 1 sub D focuses on parental failure to fulfill basic responsibility. The word neglected and unwilling are significant. Neglect refers to a parent's failure to provide proper care, dispute the child's dependence on them, whereas unwilling suggests a deliberate refusal to assume parental responsibility. The pressure adequate care, food, clothing, and shelter demonstrates that the law is concerned with ensuring that every child receives the minimum necessities required for his growth and development. The Act does not require parents to provide luxury or expectation living condition. Instead, it requires them to meet the child's basic physical and emotional needs. Consequently, where parents consistently fail to provide food, medical attention, supervision, or a safe home environment, the child may fall with the protection of Section 70 sub 1 sub D. Section 70 sub 1 sub D protects child from both physical and moral danger. Physical danger areas with children deprived of essential necessities such as food, shelter, clothing, or medical treatment. As a result, they may suffer illness, malnutrition, injury, or other serious health consequences. Moral danger is broader. A child who is left without proper supervision may be exposed to criminal activities, drugs, sexual exploitation, or other harmful influences. Therefore, the law does not require actual injury before intervention. Once parental neglect creates a real risk to the child's welfare and development, the authorities may intervene to safeguard the child. Accordingly, Section 70 sub 1 sub D adopts a preventive approach by protecting children before neglect develops into more serious abuse of parental harm. The journal article Neglecting Child Neglect selected legal issue encountered in Malaysia by Charles Zabdi, Muhammad Yusuf, and Saradivi Zambapili explains that child neglect differs from physical or sexual abuse because it involves the omission rather than a commission of behavior. The authorities further explain that neglect occurs when parents fail to provide the necessary care required by a child, including supervision, medical care, food, shelter, and clothing. Although child neglect is often perceived as less serious than physical abuse, researching demonstrates consequences are equally severe, affecting a child's physical health, emotional well-being, and psychological development. Therefore, argue that neglect should not be underestimated because prolonged parental omission may seriously impair a child's growth and development. Their discussion strongly supports Section 70 sub 1 sub D, which empowers the authorities to intervene before neglect causes irreversible harm. The importance of protecting the child's welfare is stated in Law for Kong against Pandafar, Biasar, Bagi, Killing, Dan, Kiminting, Malaysia, and 2022. Although the case concerns the correction of the birth record rather than parental neglect under Section 70 sub 1 sub D, the Federal Court emphasized that the best interest and welfare of the child must remain the primary consideration in all decisions affecting children. The court held that correcting the birth register to reflect the legal father identity was correctly in the child's best interest and welfare, and observed that this approach is consistent with the principles of the Convention on the Rights of the Child. Although the case did not directly concern child neglect, it reinforced the principle that all provisions of the Child Act 2001, including Section 17 sub 1 sub D, should be interpreted in a child-centered manner. Whenever parent neglect exposes a child to physical or moral danger, the authorities and the courts should protect the child welfare above all another consideration. In applying Section 17 sub 1 sub D, the court or relevant authorities should consider three questions. First, whether the parent has failed or is unwilling to provide adequate care, food, clothing, or shelter. Second, whether such failure exposes the child to physical or moral danger. Third, whether intervention is necessary to protect the child's welfare. For example, if parents repeatedly leave a young child alone without supervision, the child may face physical injury or become vulnerable to exploitation, like this, where parents refuse to provide sufficient food or necessary medical treatment, despite having the means to do so. The child's physical well-being is clearly jeopardized. In such circumstances, Section 17 sub 1 sub D allows the authorities to intervene before the neglect develops into permanent physical or emotional harm. The preventive approach reflects the fundamental objective of the Child Act 2001, namely to ensuring that the child's welfare and best interests remain the paramount consideration in every decision affecting the child. In conclusion, Section 17 sub 1 sub D recognizes the parental neglect is a serious form of child abuse, even where no direct violence has occurred, by allowing earlier intervention when parents neglect or refuse to provide basic care, food, clothing, or shelter. The provision protects children from both physical and moral danger before irreversible harm occurs, supported by the analysis of Charles Zabdi, Muhammad Yusuf, and Saradivi Zambapili, and reinforced by the
Federal Court emphasized on the best interest of the child in Long Fong Kong Section 17(1)(d) demonstrated that the Child Act 2001 adopts a welfare-based and child-centered approach. Ultimately, the law seeks to ensuring that every child grows up in a safe, healthy, and supportive environment where his or her well-being is always the paramount consideration.
So in conclusion, Section 17 of the Child Act 2001 ensures that children receive legal protection whenever their welfare is placed at risk. As discussed, Section 17(1)(a) protects children who have suffered abuse or are at substantial risk of abuse. Section 17(1)(b) applies where parents or guardians fail to protect a child from known harm. Section 17(1)(c) addresses situations involving inadequate parental supervision or control. And Section 17(1)(d) protects children who are exposed to physical or moral danger as a result of neglect or the failure to provide adequate care and basic necessities. Although each provision deals with a different situation, they all seek to protect children whose safety, welfare, and development are at risk. Taken together, these provisions show that the law does not wait until serious harm has already occurred before protection is available. Instead, it allows the relevant authority to intervene when there are clear signs that a child's welfare has been compromised or is likely to compromised. This ensures that children are protected at an early stage and reflects the principle that their best interest should remain the primary consideration. Section 17 therefore provides an important safeguard for vulnerable children by recognizing the different forms of abuse, neglect, and parental failure that may affect their well-being. In doing so, it helps to ensure that children are given the care, protection, and support necessary for their healthy growth and development.